Welcome to this training session on workplace violence and harassment. Violence and harassment are recognized as workplace hazards under Ontario's Occupational Health and Safety Act due to changes to the law resulting from Bill 168, which passed in 2009, and Bill 132, which became law in 2016. The purpose of this training is to help you learn about the rights and responsibilities of everyone in the workplace so that you can help prevent workplace violence and harassment, or, if it occurs, you know how to respond. The information used to create this training program was compiled from a variety of public sources and subject matter experts, in addition to excerpts from the legislation as referenced throughout this course. This course is not intended to provide legal advice, but is intended as a guide to help employees understand their rights and responsibilities under the legislation. If there is a discrepancy between this course and the Occupational Health and Safety Act, its associated regulations, or any other applicable legislation, the legislation will always prevail. Let's start with an overview of what this session will cover. During this program, you will learn about the violence and harassment provisions under Ontario's Occupational Health and Safety Act, which we will refer to as the Act throughout this course, workplace violence, workplace harassment, workplace sexual harassment, and employee responsibilities. We'll examine the legal definitions of workplace violence, workplace harassment, and workplace sexual harassment as we go through this course, but first let's briefly discuss what is meant by each. Workplace violence is the use of physical force or the threat of physical force against an employee that causes or intends to cause harm to the employee. Workplace violence can happen between two employees of the same company or by someone from outside of the workplace on an employee. Workplace harassment is a form of discrimination that involves any unwanted physical or verbal behavior that offends or humiliates an employee and includes sexual harassment. Usually harassment happens over a period of time, although depending on the severity of the actions or words, one instance can be considered workplace harassment. Workplace sexual harassment is any harassment that is based on an employee's sex, sexual orientation, gender identity, or gender expression, as well as any sexual solicitation or advance where a person is making the advance is in the position of power. Although women are approximately 3 times more likely to be sexually harassed at work, sexual harassment affects both men and women. It is everyone's responsibility to address workplace sexual harassment when they see it occurring. Let's look at some of the history behind workplace violence and harassment legislation. According to Statistics Canada, almost 1 in 5 violent incidents in Canada occurs at work. One example of this occurred in 2005 when a nurse was murdered in her workplace by a doctor who had a known history of violent behavior towards her and others. There was a clear and preventable chain of events that led to her death. This made legislators realize that changes were needed to protect Ontarians from violence and harassment at work. Protections already provided by the Criminal Code and provincial and territorial human rights codes were not enough. The workplace had to be included. Workplace sexual harassment is included in the Act, under the Section for Harassment. All of the rights and responsibilities that apply to workplace harassment also apply to workplace sexual harassment. However, the Ontario government has placed special emphasis on the need to address sexual harassment in the workplace. To reflect this special focus, this training contains a separate section on workplace sexual harassment. This section of the training will provide an overview of the workplace violence and harassment provisions outlined in the Act. Throughout this section, you will be asked to reflect on different statements and select the most accurate answer for each statement. Please note that it is not important whether or not you answer correctly or incorrectly at this stage in the training, rather that you spend some time thinking about each question. The final quiz at the very end of the course will be used to test your knowledge. A workplace includes the location of an off-site meeting or conference. True or false? The correct answer is true. While it may seem obvious, the definition of a workplace is actually more complex than it seems. Most people think of a workplace as being a building, like a factory or an office. However, a workplace can also include any land, premises, location, or thing at, upon, in, or near which a worker works. A few examples of places that may be considered workplaces are locations where off-site meetings are held, parking lots for employees, mobile workers' vehicles, clients' homes, offices that employees frequently travel to for business, and venues where an employee might attend a conference for professional development. Let's try another statement. My employer does not need to report workplace violence. True or false? The correct response is false. When an incident of workplace violence occurs or is reported to the employer should first notify police or emergency responders for immediate assistance if necessary. In addition, under the Act, an employer has a number of duties if workplace violence results in a person being killed or critically injured. If a manager becomes aware of violence or harassment in the workplace and chooses to ignore it, the manager and the company could be found liable in legal proceedings. Your employer must ensure that all known incidents of workplace violence are investigated and that appropriate action is taken. Depending on the nature of the incident and the potential threat posed to worker safety, your employer should conduct a thorough investigation, consult with other parties such as legal counsel, health and safety consultants, the Joint Health and Safety Committee or safety representative, or local police, take all reasonable and practical measures to minimize risk identified by the investigation, document the incident, its investigation, and any corrective action taken, communicate the results of the investigation and any corrective action taken to the complainant and the respondent, protect workers acting in good faith who report workplace violence or act as witnesses from reprisal or further violence, and submit a report of the incident to the Ministry of Labor when an employee incurs a lost time injury as a result of violence in the workplace. It is also important that your employer review this policy and hazard assessments annually. Roger and Theo have worked together for years. Theo is known for having a bad temper and occasionally throws tools on the ground out of anger. Yesterday, Theo shook his fist at Roger and said, "Get this done, or I will hurt you." Roger honestly believes that Theo might hurt him. Is this an example of workplace violence? Yes or no? Yes, this is an example of workplace violence. Even if Theo does not follow through on his threat, if Roger honestly believes that Theo might hurt him, this is a case of workplace violence that Roger should report. If threats are not reported, they may continue and can eventually escalate to the point of physical actions. As defined in the Act, workplace violence is the use of physical force by or against a worker which causes or could cause injury. It also includes any attempt at violence, or a threat of violence, or a behavior that a worker could reasonably interpret as a threat to cause injury. Workplace violence can take many forms, and it is important to be aware of these different forms. Some examples of workplace violence include hitting or pushing a worker, verbally threatening to physically injure a worker, written threats, notes, or emails, shaking a fist at a worker, wielding a weapon, sexually assaulting a worker, and attempting to run down an employee using a vehicle or machinery. Gina is an outside salesperson. On a recent visit to one of her clients, an angry customer stormed into the room and pushed Gina out of the way, making her fall down and twist her ankle. Is this an example of workplace violence? Yes or no? Yes, this is an example of workplace violence. As we've seen already, violence may originate within the workplace. It may also come into the workplace from outside sources. Violence may occur between coworkers, between workers and management, or between a worker and someone they deal with in the course of their work. Examples of this type of violence include an angry client or customer who threatens an employee while complaining about a product or service, a nurse who is hit by the family member of a patient, and a teacher who is physically assaulted while supervising a school trip. Outside violence could also come from someone the victim knows personally. For example, the victim of domestic violence may be attacked by a partner or family member while they're at work. As a worker, you need to know how to recognize and deal with potentially volatile situations. The nature and conditions of a workplace can be a factor. This refers to things like hours of work, such as an employee working the night shift, the location, for example if the workplace is isolated or a high-crime area, or working alone. In high-risk workplaces, management may introduce policies to help reduce the danger. For example, the danger of robbery can be reduced by introducing a policy of keeping only minimum amounts of cash or valuables outside of locked safes. Here is another scenario. Liam is an administrative professional in an office environment. To access the office, he needs to swipe his employee card in order for the door to unlock. He does not have any interaction with clients and does not handle large sums of cash. Is this an example of a high-risk workplace? Yes or no? No. Liam's workplace would not be considered a high-risk work environment. None of the factors that contribute to a workplace being high risk are present in Liam's workplace. The following environments and jobs are some higher risk examples: working with the public or in a community-based setting, handling cash, working alone, law enforcement officers, healthcare workers, social workers, and taxi drivers. The above examples are considered high risk because workers may encounter a variety of unpredictable and potentially hostile situations. It is especially important for employees in these positions to know how to deal with potentially violent situations. In addition to recognizing risks and being aware of what is available to protect you, it is important that you are provided with emergency procedures. Hopefully, these will never be required, but should an incident arise, you must know how to receive immediate assistance. Depending on where you work, personal alarms, telephones installed in specific areas, or cell phones may be provided to allow you to seek help in an emergency. Locations should also be equipped with emergency telephones, telephone numbers, and written emergency procedures. Let's cover one more workplace violence scenario. Ben recently ended a long-term relationship. Since ending his relationship, he has been receiving threats verbally and through email from his ex-partner, and lately he's been feeling watched and is concerned that his ex-partner is following him. Several of Ben's coworkers have let him know that they saw his ex-partner at the business. Should Ben let his manager know? Yes or no? Yes, Ben should let his manager know. Domestic violence becomes workplace violence or harassment when it occurs or spills over into the workplace. Employers may not see domestic violence as workplace hazards, but it can negatively affect the victim's coworkers, and the company. Domestic violence is a pattern of behavior used by one person to gain power and control over another with whom they have or have had an intimate relationship. This pattern of behavior may include physical violence, sexual, emotional, and psychological intimidation, verbal abuse, stalking, and even using electronic devices to harass or control. Employers have an obligation to reduce the risk of physical injury to workers as the result of domestic violence that has followed them to the workplace. Because victims often try to hide signs of domestic violence, some of the most obvious signs of domestic violence can come from a worker's abuser. Signs from the abuser can include a specific incident on work premises, repeated harassing phone calls or emails, stalking or harassing the employee at work, showing up at the workplace and pestering coworkers with questions about the victim, lying to coworkers, such as saying the victim is sick or home with a sick child, displaying jealous and controlling behaviors, destroying the victim's or the organization's property, and threatening or physically harming the victim or coworkers. It is also important to know when the danger of domestic violence is greatest, such as when the victim has just separated from or is planning to leave their partner, has communicated that they fear for their own life or their children's safety, is in a custody battle, is involved in another relationship, or does not have friends outside of work or extended family who can offer support. If you believe that a colleague is the victim of domestic violence or someone comes to you for help, there are a number of things you can do. Encourage the person to trust you and let them know that it is safe to reach out to you. Notify your supervisor if you are concerned for the safety of your coworker or others in the workplace. You should also let your supervisor or employer know if you suspect that one of your colleagues is being abusive. In this section, we learned that it is everyone's responsibility to recognize and report workplace violence. If it is determined by the company that any employee has been involved in violent behavior or unacceptable conduct related to another employee, the company is obligated by law to take action. Such disciplinary action may involve counseling, formal warning, or immediate dismissal. As an employee, you also have obligations. Everyone must do their part to address workplace violence when they see it. Do not be afraid to speak up and act. This next section will focus on workplace harassment. Harassment can take many different forms and may be intentional or unintentional. In many cases, workplace harassment can be addressed simply by asking the perpetrator to stop. However, if left unchecked, the behavior will often continue and may become worse. Throughout this section, you will be presented with common workplace examples. Please reflect on each example and determine if it is acceptable or not acceptable. Melissa believes that women make better employees. Currently, she is hiring for another employee. As she reviews resumes, she only selects women for interviews. Is Melissa's behavior acceptable? The behavior is not acceptable. Melissa is discriminating based on sex. Treating someone differently based on their race, gender, religion, or other protected criteria is known as discrimination. Every person has the right to be treated equally in their workplace, free of discrimination. Discrimination is treating someone differently based on their race, gender, religion, or other protected criteria. Examples of discrimination that are also harassment include things like ridiculing or teasing people because of their gender, race, or their religious dress. Discrimination may not necessarily take the form of harassment, however, it can turn into workplace harassment. Discrimination and workplace harassment may create a poisoned work environment. Greg is a manager of a department and has worked out an arrangement with Muhammad. Due to Muhammad's religious beliefs, he has requested that he have certain times to pray. Instead of taking regularly scheduled breaks, Muhammad and Greg have worked out a different schedule. Some of Greg's other employees have been grumbling that Muhammad is receiving special treatment. Is Greg's behavior acceptable? Greg's behavior is acceptable. Treating people unfairly or disrespecting their human rights is not only a compliance issue, but can lead to a hostile or poisoned work environment. Sometimes, equal treatment means treating someone differently. A poisoned work environment is one that is hostile or unwelcoming due to insulting or degrading comments or offensive actions. It can result from the behavior of employees, customers, or even management. It may or may not be in the context of racial or sexual discrimination or harassment. This does not require comments or actions to be directly aimed at a specific employee. For example, yelling at no one in particular, or pounding a desk in frustration, can affect employees even if the anger is not directed at them personally. A poisoned work environment is intimidating or oppressive to employees, and it has implications in occupational health and safety, employment legislation, and workers' compensation laws. Let's cover another example. Tony often brings seafood for lunches and likes to use the microwave in the office lunchroom to reheat his favorite dishes at lunchtime. Others in the office have taken offense to the odor and have begun to ridicule him by calling him names and decorating his cubicle with a nautical theme. Is this behavior acceptable? The behavior is not acceptable. Harassment can take many forms, including verbal, physical, visual, or environmental. It can be racial or sexual in nature. It can also include ongoing attempts at intimidation, such as bullying, as well as less direct behavior like sending inappropriate emails, making jokes, and poking fun at another person while they are not present. Harassment can include behavior that has a negative context, deliberately diminishing a person's dignity or harming their well-being. Remember, it is not the original intent of the action that matters, but the effect on the person at the receiving end. Harassment is offensive, insulting, intimidating, and hurtful. Some behaviors that could be seen as harassment may be unintentional. Other times, harassment is clearly intentional and deliberately harmful. In addition to the legal repercussions, harassment also has numerous other negative impacts on the workplace. It leads to decreased employee morale and diminished productivity. Employees who are feeling harassed are often absent from the workplace at an increased frequency. Here is another example. Paula was put on a performance improvement plan. Part of this plan requires Paula to meet with her manager on a weekly basis. During the meeting, her manager will review completed work and project status. Paula is feeling harassed because her manager doesn't treat anyone else on the team like this. Is the manager's behavior acceptable or not acceptable? Paula's manager's behavior is acceptable. There may be times when we are in uncomfortable situations that are not considered harassment, such as conversations related to missing work deadlines, progressive discipline that holds us accountable to workplace rules and procedures, receiving feedback or counseling on performance, and receiving unsatisfactory performance reviews. The workplace harassment provisions in the Act do not prevent members of management from carrying out their normal managerial duties. However, management must always adhere to standards of acceptable behavior by acting appropriately and professionally. John, who is recently divorced, has been asking several female colleagues out on dates. He even brings them flowers and chocolates as a way to impress them. Several of his female colleagues have politely declined and have asked John to stop, but he believes that persistence will pay off and continues to ask them out on dates. Would John's behavior be considered harassment? Yes or no? Yes, this behavior is harassment. By blatantly asking colleagues out, John is being inappropriate. His female colleagues have demonstrated that they are not interested. John should reasonably know that his actions are unwelcome and annoying. There are other inappropriate behaviors that may be less obvious, including using suggestive names such as honey or babe, bragging about sexual expertise, offensive jokes or comments about an employee, client, or tenant, inappropriate compliments, the display of sexually offensive pictures, graffiti, or other materials, questions or discussions about sexual activities, undermining someone's self-respect or position of responsibility, rough and vulgar humor or language, and sending vulgar or explicit emails. Take a moment to consider how someone else may perceive your humor, actions, or comments. If there is a chance that any of them could be considered offensive, they shouldn't happen at work. Stalking is repeated, persistent following with no legitimate reason and with the intention of harming or to cause anxiety or fear of harm in the person being followed. Stalking may also take the form of harassing telephone calls, computer communications, letter writing, or cyberstalking. Stalking has been identified as one of the primary risk factors leading to murder and attempted murder. It is important for both workers and employers to take stalking seriously. Even if the victim has a restraining order, there is no guarantee that the stalker will respect it. Let the police and your employer know if you or one of your employees is being stalked or if a restraining order is breached. Leanne is the head of a department and recently hired a new assistant, Adam. Often during meetings, Leanne intentionally knocks things off her desk to watch Adam bend over and pick them up. Leanne is not saying anything to Adam, and he has no clue this is going on. Would this be considered sexual harassment? Yes or no? Yes, Leanne is objectifying Adam. While he may not be aware of her intentions, it is inappropriate of her to abuse her position and power. It is one of the most blatant and harmful types of harassment. Workplace sexual harassment is defined in the Act as engaging in a course of vexatious comment or conduct against a worker in a workplace because of sex, sexual orientation, gender identity, or gender expression, where the course of comment or conduct is known or ought reasonably be known to be unwelcome, or making a sexual solicitation or advance where the person making the solicitation or advance is in a position to confer, grant, or deny a benefit or advancement to the worker, and the person knows or ought reasonably to know that the solicitation or advance is unwelcome. Sexual harassment in the workplace is an unfortunate reality for many Ontarians. A 2014 study by the Angus Reid Institute found that 28% of the Canadian workforce reported experiencing sexual harassment at work, and that women were roughly 3 times more likely to be harassed than men. These figures illustrate the need for increased efforts to protect employees against sexual harassment in the workplace, and to ensure that when it does occur, the proper action is taken in response. Sexual harassment can include any behavior in the form of words, gestures, or actions which have a negative context, deliberately diminish a person's dignity, or harm their physical or psychological well-being. This includes comments or actions based on sex or gender that are unwelcome or should reasonably be known to be unwelcome, and humiliating or annoying conduct based on the grounds of sex. Sexual harassment can be deliberate behaviors such as supervisors making unwanted sexual advances, or may include other examples such as sexually explicit jokes, inappropriate sexual emails, and bringing sexually explicit materials to work. Wendy is known for being driven and aggressive. During team meetings, she frequently interrupts her colleagues in order to share her own ideas. She has also been known to tell others that their ideas are stupid. Is Wendy's behavior acceptable or not acceptable? Wendy's behavior is not acceptable and would be considered workplace bullying. Bullying is a health and safety issue that must be addressed. Bullying has been shown to cause serious psychological harm as well as lost productivity. Something else that can negatively impact the work environment and make it uncomfortable for workers is gossip. A certain amount of gossip is almost inevitable since people want to know what is going on in their workplace and they like to discuss work issues. The key is to know when the gossip is out of hand or harmful. When gossip goes too far, it can disrupt the workplace and reduce worker productivity, hurt an employee's feelings, damage interpersonal relationships, and injure employee motivation and morale. Before repeating a story, ask yourself, is it true? Is it harmless? Is it necessary? If it is not, do not repeat it. Jose has been struggling at work. He often disagrees with his manager Wade and can't seem to understand the changes that are taking place at work. In the evening after he arrives home from work, he sometimes posts comments on his Facebook page about his frustrations, such as "Wade is a jerk," "Wade sucks," "I hate my job," and "Wade should not be a manager." Since Jose is doing this on his own time at home, is his behavior acceptable or not acceptable? Jose's behavior is not acceptable. Social media can threaten a person's right to privacy. Making comments using Twitter, blogs, and other networking sites is considered the same as making those comments in public, and employees can be held accountable for the things that they write. This can be seen by the increase in terminations and court cases related to social media and harassment. While most employers do not expect employees to avoid using social media, they do expect employees to follow some basic rules of conduct. These may include increasing the privacy of your sites. If your employment information is linked to your account, ensure that you post a statement indicating that you are not posting on behalf of the company you work for. Do not post comments about your company, clients, coworkers, or any affiliates. Do not post confidential business or personal information. And when posting comments, pictures, and information, consider your audience and who has access to your profile. This brings us to the end of Section 2. Remember, we all have a responsibility to work together and look out for each other in order to eliminate harassment from the workplace. If it is determined by your company that any employee has been involved in harassment or discrimination, immediate disciplinary action will be taken. Such disciplinary action may involve counseling or a formal warning and could result in immediate dismissal without further notice. Now that we have learned about the provisions under the Act and examined scenarios and examples of workplace violence, harassment, and sexual harassment, it is now time to learn about what responsibilities you have as an employee, including how to report complaints. Throughout this section, you will be asked to reflect on a statement and select the most accurate answer. This is the final section of this training course. It is everyone's responsibility to help create a safer workplace by preventing violence, threats of violence, domestic violence that carries over into the workplace, harassment, including sexual harassment, and discrimination, including sexual, racial, and any other type of discrimination as defined by Ontario's Human Rights Code. If I overhear an employee making fun of another employee and talking down to them, I should say something. Yes or no? The correct answer is yes. We all have a responsibility to work together and look out for each other to eliminate harassment and violence from the workplace. If you witness violence, you should report it immediately to management. If you witness harassment, you should inform the harassed person that you have witnessed what you believe to be harassment and that you find it unacceptable. Support is often welcome. Encourage the harassed person to report the incident to their manager. However, if the person tells you they do not feel that what took place was harassment, then you should respect that decision. You may also inform the harasser that you have witnessed the act and find it unacceptable. As with any safety issue, violence and harassment in the workplace are things everyone must work together to prevent. If an employee is concerned for their personal safety or well-being, or that of another worker due to violence or harassment in the workplace, they must notify their employer. Every worker must also be aware of their own actions and ensure that they are not committing any act of violence or harassment, either intentionally or unintentionally. If I feel harassed, I should probably ignore the situation. After all, the person probably did not mean to upset me. Yes or no? The correct answer is no. With minor instances of harassment, every attempt should be made to resolve matters at the individual level. The first step is to inform the individual that their behavior is unwelcome and must stop immediately. Be open to talking about it. The other person may not realize their behavior is offensive and might apologize to you. Many disputes can be resolved quickly and effectively using this approach. Management may attempt to provide support to both parties if asked, in order to resolve the incident prior to initiating a formal complaint. It is important to know your company's policy related to harassment so that you are following the steps your company has implemented. If I talk to the person and the harassment still continues, I should just ignore the situation because nothing will change. Yes or no? The correct answer is no. If an employee feels they have been harassed by someone and is unable to address the person, or if an attempt to do so fails and the behavior continues, the next step will be to file a formal complaint. Once a complaint is received, your employer has a duty to take it seriously. When dealing with complaints of harassment or violence or investigating an incident, your employer or manager should start by interviewing the complainant, the respondent, and any witnesses. Although it is important to gather as much information as possible to determine if harassment or violence has occurred, this must be balanced with the need to involve as few people as possible to maintain confidentiality. Both parties must be treated fairly without prejudging. If you are the person who has made the complaint, you should be assured that you will not face retaliation as a result of bringing the complaint forward. As an employee, you must be made aware of your rights within the investigation process. Because of the sensitive nature of the misconduct, investigations must always remain professional and confidential. Your employer may also contact a third party or someone from outside of your company to complete an investigation. Your employer is also required to provide written results of the investigation and any corrective actions that are to be taken. This notification must be to the person making the complaint and the person about whom the complaint was made. If I am a witness to an investigation, it is okay for me to talk about what happened with other colleagues. Yes or no? The correct answer is no. In investigations of violence, harassment, or discrimination, complainants and witnesses need to respect confidentiality. By talking about what you experienced or witnessed, you could threaten the integrity of the investigation. It is critical for the organization to run a complete investigation in order to learn all of the details. If you are troubled by what you witnessed, you should talk to your manager or human resources for support. If a complaint has no merit, or if it was found that no harassment or violence occurred, there can be damage done to the individual who has been accused. This is why it's important for those with information to support the complaint process and then leave the conclusions to the investigators. It is also a violation of most employers' policies for anyone to knowingly make a false complaint of harassment or to provide false information about a complaint. Individuals who submit false complaints could be subject to disciplinary and corrective action up to and including termination of employment. Ensuring the safety of workers is the most important thing, but all investigations must be based on complaints made in good faith. Employer policies must never be used to bring fraudulent or malicious complaints against fellow employees. It is important to realize that unfounded or frivolous allegations may cause both the accused person and the company significant damage. Thank you for participating in our training session on workplace violence, harassment, and sexual harassment. During this course, we learned about the violence, harassment, and sexual harassment provisions under Ontario's Occupational Health and Safety Act, workplace violence, workplace harassment, workplace sexual harassment, and employee responsibilities. We hope you have enjoyed this presentation and feel comfortable with the policies and procedures implemented to keep you safe in your work environment. The key to a positive environment is mutual respect. Thank you for participating in our session on workplace harassment and violence, covering Bills 168 and 132.